Arise, giving praises to Allah, honors to His Prophet, Noble Drew Ali, Islam. And shout out to all the members of thctrust.org. This video, I'm going to try to make this video real quick, quicker at least than most videos, hopefully. And we're going to deal with the will and testament. So, if you have a premium subscription, you should be able to follow along with this. Go to thctrust.org. Log in over here. That's not my login here. Let's do this. Oh, bro, it's calling me right now. No, just started rolling. Just started rolling. All right, now we're going right down here to where the master file menu is. And this video that I'm doing will probably go right here, this little spot. And we are gonna go right here. This is what we're gonna cover today. The will and testament. Now, we started just a real quick brief overview. Step 1 dealt with personal status correction. Whether it's affidavits of nationality, your tribal ancestry, whatever it is that deals with your personal status correction. Then we went into the revocable trust, which some people refer to as the living trust because that is the trust that titles the estate, which the estate in some instances will be evidenced by the certificate of live birth. So when people are always saying, did you set up your trust? A lot of times they're talking about the trust that's going to title the estate or the living trust, revocable trust. And again, it's called living because the terms of the trust can be changed or the trust can be revoked during the life of the grantor, basically. So that was kind of the second step. And we didn't really talk about titling assets in the trust because remember, the living trust is going to title the assets. It's going to take the assets out of the individual name and put those assets in trust. Therefore, kind of like you can say taking them out of the public ledger and putting them on your ledger. Might be one way of saying it. So it's important, as we talked about in that revocable trust, that you appoint a successor trustee. And the reason is because the revocable trust is connected to the will and testament, because this will and testament transfers any assets that remain outside of the trust at death. It transfers them into the trust. And that's the kind of the completion of keeping the estate out of probate. So take a quick look at that. All right. So if we look at the last will and testament, and if you're going to do this on your own, just look up what's called a pour over will. That's kind of where we started from with this template. But the important part is let's just go down to disposition of property, Article 2. All of the property that I own at my death, or which shall become payable to my estate or my personal representatives, for which I have the power to dispose of under my will, shall be transferred to the beneficiary, Doe Living Trust, dated, whatever date. So by this time, which is why I talked about the trust registration statement, you'll already have that trust registration statement, which can identify the actual trust to which all the property remaining at death gets transferred to. Now, so now to have any real evidence of the existence of that trust, you just basically have to use that trust registration statement in commerce, say like on the UCC or a memorandum of trust. You don't really have to use the trust registration statement, but I was just saying the whole deal is if you're holding your trust off of a public record as a private book, then if you're transferring estate in your will to that trust, you have to have evidence of the existence of that trust. So this is another reason why you probably would want to use the full trust registration statement here, because it'll identify the trustee, it'll identify whether there's an indenture on the trust or an agreement, it'll identify the important information, and it'll give the date of the instrument. So that way, if you were to ever pass form and this was to end up in probate, the trustee only would need to produce those trust documents and it will authenticate who he is. Hope that makes sense. But enough said about that. That's all the important things in here. Also, there's a nomination of a personal representative. I nominate James Doe as my executor and personal representative. So who would this person be? In the scenario that I've set up, in my revocable living trust, there's a successor trustee, right? That successor trustee is the same as the nominated executor and personal representative in this last will and testament. Another thing that is also very important, I would say 3 to be safe. Definitely don't just do 2. I wouldn't do 2, I would do 3 to be safe. But even to be safer, I would go look up the requirements in your state. Alright, so now we're going to continue talking about the will. And now we're going to talk about recording the will, which can prove to be a little bit of a difficult task because the counties really fight you on this. And I think they fight you for a couple of different reasons. I'm not exactly sure, but for some things to understand is by default, you're considered to be in a status, particularly African Americans. You're considered to be in a status as a ward of the estate. So the ward is someone who doesn't have control or competency of the estate. He's basically controlled and told what to do. He's basically in custody is what a ward is. So he's limited, you know. So, and this is where you have the terms because a man who has all of his rights intact has a will in place because he has the authority to make a will. That's a part of he has a will. It's a part of I mean, you could look at it as he has a will on a record as far as what he wants to do to dispose of his property, but he also has a will to be free to do whatever it is he wants to do and not to be in the custodian of someone such as a guardian or whoever. So neither here nor there. There's this ward status that's automatically presumed. So this might be part of the reason why they don't want you to record a will, because the will is the way that a man directs the disposition of his property, and through the will the man appoints the executor, who now has the authority to take hold and possession of his property, which in essence to some degree I see could, let's say in theory or in law, however you look at it, it can remove assets from the county's ledger and put them on your own ledger. So this could be one of the reasons, I'm just saying potentially this could be one of the reasons why it's met with so much resistance. Plus there's sometimes, as we see, we go into courts and we don't understand all the different jurisdictional things that's going on. Well, when you look up wills, they have things called the mystic will and the secret will, and then they have wills. Well, a requirement of wills is that they're supposed to be published, but then they talk about other types of wills like the mystic will, and that type of will isn't published. And an interesting thing is when I went to the probate court to record my will, it was actually they made it clear to say that this is not this is not public record, and they give you a safekeeping receipt. So that is a deposit. Now that's a whole nother level that people probably can take and go with that when you think about special deposits and instructions and things like that. But that's not really what I'm talking about here. I'm just kind of giving you information that I found. I don't have all the answers to this yet. So I know that that type of will, even recorded with the probate, isn't considered published. So it's not complete. if you will, to my understanding. However, it still is necessary because I want to make sure that the estate is set up the proper way to make sure that everything is held outside of probate, and so that I can have a clear chain of record that there is a will in effect should I ever have to deal with the situation of an administrator or an executor de son tort, as they say, which is the executor who's wrongfully holding position in the estate where he's supposed to relinquish it. So, that's. But anyway, they meet you with a lot of resistance. It seems like a simple thing, but it's not. Some people have already found that out. But if you do get met with resistance, ask them why. Ask them to demonstrate with you what must be done so it can be recorded. Ask them to give you a rejection letter. Ask them to put it in writing. And, do your own due diligence. And then, lastly, and importantly, I want to get to the Uniform International Wills Act. The Uniform International Wills Act, this is a separate system for recording your will. And it does get recorded to the registrar with the state. It may be considered published. It may be considered public record. I don't know. I would suggest that before you record your will under the International Wills Act, that first you record it behind your UCC filing. You have your own public record of that will, or your record of that will. I'm not sure if that's still considered a public record or not. And if you don't do the UCC, the UCC part is probably unnecessary if you were not one of the people who were met with so much resistance that you couldn't get your will recorded in your county, right? So anyway, after you have that document, you can use this. Click it here. This is the Uniform International Wills Act, Uniform Probate Code. This has to do with a conference and a commission that took place in the 1970s, where they came together based off of, I'm paraphrasing from my understanding, based off of different treaty obligations that the United States had. It pretty much imposed this legislation on the states, kind of requiring them to come to some type of agreement to accept this federal standard of an international will, because usually the federal government doesn't take place in that part of things. But I think it came down to a matter of constitutional rights and treaty rights. Neither here nor there. You can read about it because the links are in here. But when you read through this, they give you an example certificate of what was presented to the states and what seems to be what was accepted by the states. Because the example that is put in here is very similar to the sample certificate, it's very similar to the example certificate given in California that's required to accompany the will to be recorded with the Secretary of State on the registrar as an international will, which I believe that is, again, something that deals with private international law. So this is another way, if probably not the proper way, to actually have your will recorded. And again, like I said, they have an example in here. But what you always have to do before this, see, there's the certificate, and you can read through it about what this certificate must say. But even before you do this, you have to go to your local state statutes and type in or research their what it says in your statute as far as their certificate for international will. And you're probably going to find that your state also has this second system in here for recording wills with your Secretary of State, and they give you this form of a certificate.